it does seem odd to be talking about land use in a case that has to do with immigration and employment, but it goes back to the broad language of the measure, which is based on statewide applicability and expanded definitions. For instance, license is now defined as any license, any permit issued by any agency for the purpose of operating a business in this state. It specifically includes a building permit and a business license. So what this does is essentially add a new criteria to land use planning. So no longer, you're supposed to make land use decisions under Oregon's land use law based solely on Oregon's statewide planning goals. But by adding in this definition of license and these definitions of employers, you have essentially created new criteria because a county no longer has to look at only is the land use permit entitled because it's sufficiently set back from a riparian area or meets FARs or is up to a structural code. You have to now look at a land use decision based on a filter of whether or not somebody knowingly or intentionally employed an illegal immigrant. And not only was the process used for setting up this new criteria outside the land use system, it also sets up a contradictory appeal route. As Mr. Lilly has noted, land use appeals are strictly jurisdictionally proceed through LUBA. The measure in the ordinance, however, specifies that the Board of Commissioners or a justice court would hear land use, building, and permit appeals based on immigration status. Similar to the ordinance.
Now, is there a concern there about expanding the jurisdiction of justice courts?
There is, Your Honor. I believe justice courts have the authority to hear only lower level measures and up to $7,500.
Right. I believe that they might be able to hear residential eviction cases, but I don't believe that they're able to deal with any other matter involving real property.
We would agree, Your Honor. The ordinance and measure are similarly preempted by the Oregon Building Code and the Oregon Construction Contractors and Contract Code, both of which include express preemption clauses retaining exclusive authority for the state to regulate building permits and contractor licenses. Outside of the land use arena, the measure and ordinance consist of state laws regarding official misconduct, which are criminal misdemeanors requiring violation of a state statute, not an ordinance. Under state law, the knowing violation of a statute relating to a public official's office is official misconduct. But under the county scheme, an official may be charged with official misconduct for failure to enforce or uphold the law, and those are terms that are left onerously vague and undefined. The measure might interfere with the lawful functions of the district attorney, and I say might because the ordinance, of course, cleaned up that language some and eliminated some of the confusion regarding the non-existent office of county attorney and put the burden on its own county counsel for the investigation and enforcement provisions. But if county attorney was determined to mean the Columbia County district attorney, then the measure does conflict with state law. DAs generally have the exclusive authority to determine whether or not to prosecute violations as the state representative for law enforcement. And the expedited enforcement scheme would require the DA to give priority to processing complaints over other duties. Violating the measure in ordinance also violates.
Can I interrupt you for
Sure.
a second? So, Mr. Lilly suggested that my focus should only be on the ordinance, but the ordinance contains a provision that says if the measure fails, that the ordinance is repealed. And so if you have a term, county council, that is argued successfully to be ambiguous, how should the court deal with that? If, I suppose the argument is the term county council could either be the district attorney or could be hired at the pleasure of the county commissioners or the district attorney who is an elected state official, which obviously a pretty wide difference in who would engage in that function. And so your argument would be that the ordinance, by identifying who's going to be responsible for the enforcement, does or does not cure that problem in the underlying measure.
I think that depends on on whether you decide that the clause within the measure that made it that said that the county could not adopt an ordinance.
I don't believe that there's any basis in the measure itself to determine the definition of county attorney.
No, Your Honor. And that actually does get to the next point that I was coming up on, which is
Move into that.
That even if this measure was not preempted and didn't exceed the legislative authority, there are so many errors, like the one that you're describing right now, that the measure and ordinance, since it's fairly different, should be stricken. The other errors that are in the measure include unreasonable retroactive deadlines. As of December 31st, 2007, nearly a year before the measure had passed, it would have required employers to have begun verifying employment eligibility using the E-Verify system. And as many of us have heard in the news, that system isn't even being required by the federal government for its own contractors because there are so many uncertainties. As of October 1st, 2008, the county would have had to have started notifying employers about the new law. Since they've not done that, technically they could be held failing to have enforced that measure and face official misconduct charges. It's incomplete. It has, in addition to the vague county attorney definition, it has intentionally shall be defined as or as blank. And some arguments have been made that there is a severability clause, but in this case, you cannot sever in order to save this law. The invalid parts and the valid parts are so entwined, it must be invalidated as a whole. Determining whether an invalid provision, like the definition of the county attorney or any of the other points that I mentioned, determining whether an invalid provision is severable requires the court to construe the measure in the manner that best reflects the intentions of the voters or the entity that enacted it. If the court agrees with the provisions I've discussed and that Mr. Dale will discuss are invalid, what you have is a mere shell of the measure remaining. You have no definition for license. You have a limited definition of employer. If you strike the incomplete definition of intentional, et cetera, what you're left with is basically a law that prevents an employer from knowingly or intentionally prohibiting an unauthorized immigrant. And we basically have a law called the Immigration Reform Control Act, 8 U.S.C. 1324A, which provides that same requirement. The only thing that you may be left with is perhaps a requirement that violations result in the filing of reports or sworn statements that I'm not going to do it again. But that scheme is really just a mere ghost of the legislation that was originally passed. And it cannot embody the spirit that was expressed by the drafter of this measure, which was to, quote, scare local employers, particularly general contractors, who would bear the brunt of the measure's punitive measures. And so the $10,000 fine and those punitive measures that result in permanent revocations and licenses and fees are integral parts of the measure. And so the valid provisions, when they're left standing, cannot embody the original legislative intent. And again, because of the repealer that we